as doctors, it's our responsibility to see to it that we know the laws, whatever that's applicable to our profession, and do that, and do all the activities that we are supposed to do. But everything's fine. But one fine day, you get a notice from a lawyer. That day, you start sweating. And then your pulse goes up, your BP increases, you become a patient. And what to do at that time? So it is a big tricky question. So handling legal notice and summons is one of the most important things that we have to know practically in every hospital setup and in every practice. So to explain that, we have an eminent doctor who has been practicing for such a long time, who is a very senior person in the profession. He graduated from the prestigious Madras Medical College, and he has been a family practitioner for the past 3 decades and has been managing a 100-bed chain of hospitals for the past 25 years. He completed his diploma in family medicine from Colombo University and has done his postgraduate diploma in medical law and ethics from the National Law School, Bangalore. He was an active IMA member and has been holding very important posts in IMA Tamil Nadu as well as the national headquarters with distinction. He was one of the founder trustees of the Professional Indemnity Scheme for Doctors. He has been a faculty of the Anna Institute of Management, the Government of Tamil Nadu, and several medical colleges on the medico-legal aspect, and is also a recipient of many awards. Ladies and gentlemen, presenting to you Dr. N Ravisankar, former president, IMA Tamil Nadu. Over to you, sir.
Thank you. Thank you for your nice words of introduction. These always creep into our brain and mind. If it creeps into our mind, we keep working better. And if it keeps into your heart and anywhere else, I think something is getting heavy on your head. Let me not be that way. Let me thank the CAO and in particular Dr. Anuradha Pichmane for the opportunity she got for me to be with you all on this evening. I think whatever you said is absolutely fine. Till you get a lawyer notice, till you get a court summon, you are happily practicing your profession. But then once you get it, the jitter comes into it, you get palpated, and you are already in the ICU. You will know you need to be treated by a psychiatrist and a lawyer who can definitely defend you in the court of law. Before we go to how we handle a case, let me see what are the causes that usually cause a problem in a hospital. And these 3 things are there: the communication, the cash that the patient will have to shell out to you for what they have to get back for their health services. And always the casual attitude at times. Whoever does it in a hospital atmosphere is going to cause a problem. And this is where you get the friction in the hospital. And who are the people who are causing the major frictions in the hospital? Are here the front office. We always say when whatever that is detected correctly when the patient reaches your place, it's definitely going to give a good reputation. And if there is going to be a wrong thing that happens in your front office, more so with your security entrance, where you come down for parking your vehicle, naturally that is the source of all the litigations that can happen. And that one point, it can stimulate the patients and their attenders to any extent. There is always the nursing department, the ward boys, subordinates, and in the present scenario, the insurance companies. There, I think Mr. Sanjay Pitto already told us that the insurance companies' only aim is to disapprove all your claims, and in spite of it, they do get the benefit, but at times the cost is cutting down, so they will have to shell out from their pocket. And naturally, that is another big source. Cash and insurance is a big problem. Laboratory diagnosis, if it doesn't give a proper reports, the Google is always there to help them, whether it is correct or wrong, because the patient trusts the Google rather than the pharmacy place is another place. Today, we have Humpty number of pharmacies chain that provides a lot of discounts. The availability, and if your staff doesn't inform them this is not a drug which has been prescribed, we are substituting, that can be a source of issue. And then the infrastructure. Quite a number of hospitals have received notices only on the infrastructure. Today in the pandemic, I think everybody will be knowing that the availability of oxygen has been a major cause. The other minor departments, which I said, the security, the food that has been supplied, there is always a stone in between the foods that has been supplied once in a while. And the patient care personals who are there provided in the hospital entrance to take the patients to the ward or to the outpatient department. And that is where their body language and their involvement and commitments also come into play, which are the regular causes. And people would have thought why the medical personnel's cost has not been enlisted, and that if we enlist the medical personnel cost, I don't think it can be finished in a single slide, because it is this medical personnel and next the hospital that are being targeted, and any small thing that can happen the other way than the expected way of the patient can always stimulate the issues. The qualification, the availability, the delay arrival, not referring for a second opinion, a casual attitude that's been always told in a highly good language as body language, not responding to your request. Quite often they want to get discharged earlier or refer to a higher center or something else, and we don't do it. And then the poor communication might not creep into the minds of the doctors. These are things which the doctors uh, don't think really necessary until we receive a notice. And then in those, another cause is the failure to diagnose, ignoring the laboratory report, which you already said, unnecessary surgery, quite often on the cesarean section, on an acute appendicitis, or something on the ENT department. These are departments often land up in an allegation of unnecessary surgery. A surgical error, like already been told, a foreign body, wrong food, wrong diagnosis and wrong surgery. Improper medication and dosage. I think the Kunal Chat case, everybody will be knowing, which went in for the highest compensation in this country. Poor follow-up. If you don't follow up the patients until they are discharged, and even after discharge until the patient is perfectly out of the complaint for which he had been under treatment with you, they can always take you for a medical negligence in the court of law. Premature discharge or a delayed discharge, whatever it is, wherever it is, the patients want anything. This is where the communication and heeding to the patient's request is very much important. These are things that can prevent the litigation, and if there is going to be litigation, these are the places where you can be taken to the court of law. A criminal case, if there is a gross negligence, Jacob Matthews gives a guideline, and a civil case, as long as the consumer courts was not there, there were civil cases. Everybody knows the table tennis Chandrasekhar case, and then subsequently the consumer courts have come to the rescue of the citizens to be a harassment for the medical professionals. And Human Rights Commission now and then enter into the scenario trying to find fault in a different situation if the patient doesn't have the right or a legal base to go for any of the above three cases. And what is a lawyer notice? It's the first social for what you have done, a good service or a bad service or an inadequate service. And I always say it is a certificate for your service. The certificate may be in the black and white or white and black, whichever way you want to take it, you can take it. And it is not alone the lawyers in the courts that can take you to the problem. There are the district medical officer or the JD's inquiry. If there is a complaint they receive against you, based on that complaint, the patient can take you to the court of law. The department or the institutional head can also initiate an inquiry against you, which can result in your trouble in your practicing of profession. Insurance companies have now got the right to inquire on things that can go wrong in your practice. And quite often the CM cells receives complaints if the patient is unable to get relief in another way. And if they want to get an earlier relief, they always go to the CM cell, and the CM cell will then depute the district medical officer or JD to find and inquire and report back to them. And quite every time if it goes to the CM cell, I think you can imagine what it will be. And the worst thing is that to get a political pretension if you are facing a problem in your hospital in practice. All these things are the way how you are likely to get a court notice or a lawyer notice. But then the best option for a hospital or a doctor, if there is really a medical negligence or if there is an unsatisfied patient, is better a court summon rather than handling the above situations which are not under control. And in a court summons, if the court is going to handle the situation, these are better things in your adversity. There is a law that is there which is going to give a framework on how the case is to be handled. And there is a right person sitting in the court who has got the knowledge of the law, and there are people in the medical profession to support him, because your advocates work is to present your case properly with the scientific evidence to get a judgment in your favor. And so it is better to get a court summons than the what I have told in the previous slides. And what is a lawyer notice? It is a teaser which we always often see before a film. And then the feature film is the one that goes to the court. It is those days we had the civil courts where things are handled like Ben-Hur film, which we have seen, which was running for 3 hours and 45 minutes. Every court will take such a long duration. And then the feature film also goes to the higher forum. And that's at that point of time, it is Bahubali. Whether you finish it in the state forum and then go to the national forum. If you are not satisfied or if the opposite party is not satisfied, you can take it to the Supreme Court. That is what happened in the Kunal Shah case. That is Bahubali 1, 2. Now they don't want the Bahubali 3 because they have exhausted the resources of making money on that. And never a short film is there in a lawyer notice or a court summons. And if it is going to be a short film, I think you can imagine who has to live a shorter life. And even if there is going to be a short life for any one of the party, the legal hire will have to face the case in the court. And how do you have to reply for a lawyer notice or a court summons? It's like reading a love letter. If you have got a love letter in your college days, or even later, or much later in your life, it is better you read it, reread it, recapture what was the cause for everything, try to record the events, and try to recollect the documents. I think if you have all these things in your hand, you can very well easily handle any court cases or whatever it is. Like how you have preserved your love letter for your lifelong. I think you will have to preserve in memory whatever that has happened in your practice. And if you can't preserve it today, the Code of Medical Ethics says that you need to document even if it is going to be on a digital platform. Digital platform is becoming the order of the day. I think every practitioner, and that too when it is on cloud, when NABH is there, I think you will always insist on a digital platform where we document things. A love letter can be remembered in your mind and heart, but never a treating a patient for long years that has to happen. And whenever you handle a lawyer notice or a case or a court summons, try to find out whether it is within the normal period. The condemnation of the time and that awareness of the incident, awareness of the complication of the surgery that has happened. Surgery that had happened in 2000 and a pregnancy that had happened in 2008, and the patient has got the right to take you to the court of law until 2010. That is where the time limit is also given there. And 2 years after the incident, that is awareness of the negligence that has happened. When you do have a condemnation of time, there is always another doctor trying to give a certificate for the patient that he was not sick, that he was sick, not conscious, unconscious, whatever it is for 2 years. And then there are a number of cases in the court that had medical certificates which have given a lot of explanation on the condemnation of time. Be careful about it before accepting the court. And if you give it to the lawyer, they will be able to find it out. They will not know when the incident has happened. If that has to be known to them, it is better that you give the proper history to the lawyer who's going to handle the case for you. And I think it is already told to you what are the components of medical negligence, like the duty of care, breach of duty, damages caused by the breach of such legal duties. It's here that I would like to concentrate a bit on this slide. So hereafter, the allegations on the lawyer notice or on the court summons will have to be charted down. That's the first important thing that any medical practitioner who is involved in the case or a hospital management who really has got a difficulty of receiving a court summons or a draft from the court. You please chart and read it down carefully and charter down 1, 2, 3, 4. What are the allegations that has been passed on the consultants of the hospital or in the hospital infrastructure or whatever it is? There can always be a complaint against the doctor and the diagnosis and the treatment modality. And then there is always complaint against a paramedical who might have behaved in an odd way, their body language, or the subordinates. The person who was pulling on the wheelchair, or the person in the radiology department, or the person in the laboratory, and try to chart out 1, 2, 3, 4. Who are all the people involved and what are the allegations? and try to match each other the allegations of who is involved in what are the allegations. And finally, try to understand if you are a hospital owner, what are the infrastructures that has been the cause for the allegations in the notice. And not only the infrastructure, there may be inadequacy in the hospital, non-availability of equipment, and non-availability of medicine, non-availability of consultants at certain point of time. These are the allegations that really take you to trouble in the consumer courts. And Indian Evidence Act clearly says the burden of proof is on the people, on the person who is putting the allegation. The onus of proving is on the complaint as per section 101. And section 45 gives the option of the medical person to get an expert opinion to substantiate that they had been treating the patient with the standard operating procedure or the accepted protocols. And that Indian Evidence Act is supporting in the consumer courts the doctors for that professional work if they have done it perfectly. Documents, it is always called in the consumer courts are called documentary evidence process. And in the documentary evidence process, we need to show the evidence for our positive work that we have done. And there are also evidences to be shown for the allegations that are against us, that is all the negative things that has been passed on against an allegations against us. Today, the video evidence is much more there in the courts and in the law. And you need to have a number of times when I always say the prevention aspect, when there is going to be a polytrauma, more than 2 consultants or 1 consultant involved in a case to treat. And if it is going to be a complicated case, and if the outcome is in doubt, it is better to have a video evidence of the concern that we have taken, not only on the documentary side, but also on a video note. Let me come on the biometric, when they say that the allegation will always be there that the staff nurse was not there in adequate in the hospital. They were not qualified. These things can be proved in the court of law when you take the employee's certificate on the first day when they join. And your HR should have all the staff's qualification certificate, a copy of it, and verify those copy also with the respective statutory bodies. If you are going to be a staff nurse, today getting a fake certificate is very, very easy, and be careful about that. And if you do get a certificate from your paramedicals, try to verify it and cross-check it and keep it ready in case there is a problem anywhere. You need to produce this evidence in the court of law. This is one which is going to defend you, because quite often the allegation against the hospital is that they have only unqualified staff. You can't have totally, if you're having 50 staffs in your hospital, you can't have 50 qualified staffs. 2 ways it is not possible. Neither the availability nor the financial status to pay for 50 staffs. We do have 20-25 staffs who are qualified, who have the qualification, and there are another 10-15 people who are trained, or another 10 people who are trained for long years, who do have certificates of their capability. And these are things which have to be kept in your HR department. And biometric is very, very important these days. And if you have a biometric properly kept by your staffs, you can prove in the court of law that these consultants or these paramedicals or these substaffs have been present in the hospital at that point of time. The allegation is night duty, you have only 1 staff to cater the entire ward with more than 10 people or 15 people. I don't know if that. If that is so, your biometric should be proper, and your CCTV is another one which is very, very important to show an evidence that who walks in, who walks out, how your case sheet is missing, and whatever it is can be taken out by your CCTV. But what we always do is we don't try to keep the record of the CCTV more than 8 days, and that is where the trouble comes. The laboratory people, if they are really in trouble in this whole issue, you have that time of the treatment, that is the reports that has been available in the hospital. That's very, very, why the video consent, I missed another point, is they always have an allegation against your ward boys that they pulled on the stretcher or the wheelchair with force or anything like that. Your video evidence is going to be there. But most of the time, some of the times we do have the patient falling off the stretcher, the hands hanging down on the side, getting injured, or when they are wheeling down the wheelchair, your hands or the legs get dragged on. The video evidence is going to help you in the court of law in all these situations. And then your standard treatment protocols, the most important thing that is going to, the Pomeroy's technique where the sterilization failure, what is the percentage of failure that is there for that surgery is in your standard textbooks, and that has to be quoted. And if you have taken a cesarean section for a person with the different complications and ideas, then you need to take your protocols from your textbook, how you have to defend yourself in the court of law, saying what is the percentage of cord around the neck is being taken for cesarean section, what is the minimal chance of them going in for a normal delivery, and if they do go for a normal delivery, what is the chances of the baby getting asphyxiated and in trouble. This applies for the plastic surgery also. Most of the time in the plastic surgery, we need to take a photograph before the surgery and a photograph after the surgery, which is going to be a positive evidence for you in the court of law. And there is somebody who is going to have a surgery done for a nerve palsy or anything. Prior surgery, charter down their muscle power, charter down with a proper person, a neurologist, and also a physiotherapist. And then after surgery, what is the evidence for that? These are documentary evidence which are really going to matter a lot in the court of law, because it is these documents that are going to speak volumes. It is not the cross-examination of your consultant or the cross-examination of the patient that is going to bring out things that is going to help you to defend yourself in the court of law. The standard operating procedures, standard textbooks that are going to help you in the court of law. There is another one with our orthopedic surgeons. The patient with their for the financial reason might accept for a low quality implant. But then after 2 years, if there is going to be a fracture and if there is going to be a failure or if there is going to be a foreign body reaction, they're going to give an allegation against you. And when at that point of time, they will say, had you told me this is going to be a problem, we would have accepted for the costly one. But then when he's on a compromising note on a financial situation, you need to take an evidence in your record, keep it in the case sheet, today we stick down the stickers of the implants that is there in your case sheet for records forever. These are things which is going to help you in the court of law. That is the standard operating procedure. And today, if we have tried to do something new to the patient, like what we have been doing in the COVID period, the protocols have been changing quite often. But then there is a journal evidence which says CQE is useful, not useful, indomethacin is useful, not useful, steroids, these are useful, dexamethasone for this, methylprednisolone for this. Today, treating COVID is depending on journal evidence rather than textbook evidence, because textbooks have still not come around COVID treatments or protocol. So try to follow whatever is available by the standard associations and organizations for the sake of defending yourself in the court of law. I think this is once again, the same thing which has been repeated. Even if you take all precautions and do things cannot go as expected. And that is called an accident. And in an accident, there are things which can defend yourself in the court of law. Section A of the IPC, accident and doing a lawful act, that is the Medical Professionals Doctors Act. An act not intended to cause death, done by concern and good faith for first person's benefit. A surgery that is being done for a patient is all done in good faith. And these are things for as far as the consumer courts are concerned. But in a criminal courts, it is only gross negligence as per Jacob Matthew case. Wrong surgery, wrong patient, wrong organ, all these things are obvious as per Lockiter, and that in those situations we can't escape. When there is a criminal case filed against you, they need to get a competent second opinion, and that is where the Indian Evidence Act Section 45 comes into force. And then not only the act, but also the judgment of the Supreme Court of Jacob Matthews comes down into play whenever you are doing it. And I always say, when there is a lawyer notice and when there is a court notice, there is a big difference of trying to put down the evidence or document. Whenever there is a lawyer notice, try to give a proper defense, but don't reveal the last defense that is available for you. But when there is a court notice, never even ever miss the smallest thing that can help you to get out of the case. I always say the lawyer notice, if you charter it down perfectly for a lawyer notice, all points that is there, and then that is going to help you in the court of law. And then finally, you have the case laws in both the situations. You need to quote down the case laws. The similar case would have happened in a higher forum. If your case is there in the state forum, then you need to quote a case that has happened in the national forum. And if something is in the state, something in the district, you can always quote what has happened in a state forum or in a national forum. A case law, it is not only you who had undergone a case of that nature. Every case that has come to the court is always a similar case, almost a similar case that has happened earlier for a different doctor in a different court. And it is the duty of your lawyer to find out the case law and give you the details of the case law, quote down the case law, what the previous judgment has said, and take it forward for your support in all these things. This is what I took it from one of the websites. It says how you have to file a case against a doctor, whether it is possible to file a case against a doctor. He says, procure all the receipts, documents, records of your hospital treatment, issue a legal notice to the hospital for the compensation, and return the excess charges paid. If not responding, file a consumer court case for the gross negligence and unfair trade practice. Look, he has not talked anything about the negligence. He had only talked about the excess charge paid. And they always have a charge that hospitals are charging more. It is not the hospital that is charging more. It is the way that the Indian system, the economy system is that we are forced to charge more. And because you charge more, you will end up with the gross negligence and unfair trade practice. This is what the common notion when you receive a court notice or a court summons. But then there is always a conscious in your practice that you do practice your profession ethically and with the mother's touch, where you always try to take care of the child. You're trying to take care of your patients perfectly. If you keep doing that, I don't think a lawyer notice or a court note someone will be issued to you. And even if that is issued to you, I think you can always come around when the law will be on your side. And if you are observed the standard treatment protocols, and if you give your documents perfectly, it is the documents that is going to speak volumes to the court of law. And if your standard operating procedure or qualification or accepting the protocols that is needed for in a hospital practice, I think that is always going to defend yourself in the court of law. Thank you for your attention and patient hearing, and I'm willing to take questions. Thank you very much again.
So thank you very much. One question, is video consent admissible in the court of law? That is the question.
Sir, it is being taken up in the court of law, but we always say never try to do a video consent most of the time, because then the next question will be, have you video recorded the treatment or the surgical procedure? And the court may ask you more evidence, where that evidence will always be a troublesome for us. So it is better not that way. Video consent has, as far as the procedures are concerned, I don't think it has now come into play. But video consent on the financial aspect that we have explained whatever cost is going to be involved has been presented in the court of law.
Thank you very much, sir.
Thank you. Thank you.